Good afternoon, everyone. I'm Gillian Sadler, Chair of the Ulster Society, and I'd like to welcome you all to the latest in our series of webinars with our legal partner, A&L Goodbody. We're really grateful to A&L Goodbody for their time and expertise, and the feedback throughout this series has been really positive. And if anybody wants to catch up on any of the previous webinars, you can do so via our website, charteredaccountants.ie/Ulster. For today's webinar, we have Stephen Geoghan focusing on the Procurement Act 2023. The Procurement Act went live at the end of last month, so it's certainly a hot topic for the profession, for business in general, and for the public sector. The Act is being viewed as the biggest shake-up in the UK public sector procurement in decades. So today we're going to be taking a closer look at the new regulations and hopefully helping members to address some of the opportunities. Stephen will be presenting a detailed analysis of the new regulations covering the procurement process, how to engage early and protect your business, the post-contract award, asking is your contract at risk of termination, and he'll be outlining some key takeaways on the biggest learnings for business as a result of the new regulations. Stephen is an associate at A&L Goodbody's Litigation Department in Belfast. He specialises in public and regulatory law and has a wide range of experience in advising registered charities, housing associations and industrial and provident societies. His practice areas include procurement, judicial review, regulatory law, and acting on behalf of regulated utilities and companies in the energy sector. We'll have some time for Q&A following Stephen's presentation, so please do feel free to add any questions you have into the Q&A box at the bottom of your screen. The Q&A is open now, so just go ahead and add any questions at any stage throughout the webinar. I would just ask you to keep your questions general. Stephen can't answer specific legal queries during the webinar, but should you wish to contact him directly on a more detailed manner, we can, of course, share his contact details. So we have a lot to get through. We'll get started. And Stephen, I'll just hand over to you. Thank you.
Thank you, Gillian. My name's Stephen Geoghan. I am a senior associate at A&L Goodbody, NI. And the seminar, as Gillian has already touched on, is going to be on the Procurement Act, which came into force in February 2025. Given the extent of the changes, it was delayed. It was initially due to come in November 24. So I thought a good place to start would be touching on the old regime, which was broadly made up of 4 different regulations: the public contracts regulations, the utilities contracts regulations, the concession contracts regs 2016, and the defence and security contracts regs. The idea of bringing in the new act was an overhaul in public procurement to streamline the process. So of course we went from 4 sets of regulations and we now have 6. The new regulations are broadly made up of the Procurement Act 23, the Procurement Regulations 2024, 4 subsequent regulations, and more than 40 Cabinet Office guidance notes. And the public procurement policy notes also continue to apply. So you see, it's quite an extensive regulatory regime for public procurement, and probably rightly so, given the extent of public money and public contracts that are awarded through the procurement process in Northern Ireland and throughout the UK. The background to the introduction of the new Act is that we wanted to move away, we as the UK wanted to move away from the old directives that underpinned the previous procurement regulations. So it was a bit of a ripping up, starting again, albeit a lot of the concepts survived, and there's a lot of old wine and new bottles to an extent, and you see as we go through, some of the terminology that is used is very similar to the previous regime, albeit with slight nuances. It'll be interesting to see how the courts perceive the obligations, either similarly or how far they depart from what was previously went. Probably the biggest shake-up, and I'll touch on this later, is that rather than having a procurement process and moving to a contract phase, the Act seeks to take in the full life cycle from policy development stage right through the procurement stage, right through to the termination of any public contract. The Act specifically sets out, and in the Cabinet Office guidance, it sets out that there's now 4 stages: the plan, define, procure, and management phase. The management phase is probably the most interesting phase for anyone that has a public contract, but the plan and define stage would be of particular importance to contracting authorities, um, because they will now have to engage a lot earlier in the process, when procuring a public contract, to make sure that their policy, their objectives are all set out and thought through, because there's a reef of new requirements and obligations upon them under the new Procurement Act. Then we'll move on through the procurement specific phases, and the management phase. Assume that there's a case that that everything goes well. You get through the define stage, the procure stage, you get to the management stage. There's a lot more requirements on contracting authorities and a lot more risk for suppliers, because throughout the course of the contract, there is going to be new transparency obligations. There's going to be new grounds of challenge arising. There's going to be potentially new public law grounds of challenge arising. And that is all now encompassed through the Act. If you're a utility, the first thing you want, or sorry, a contract authority, the first thing you want to do, or if you're working with a contract authority, assisting them with public procurement, the first thing they want to do is understand what is their status under the Act. The Act sets out there's 3 types of contract authority now: the public authority, a public undertaking, or a private utility. Essentially, the starting point is that you complete an assessment to work out what category your organisation falls in, or the organisation that you're advising falls within, because that will have a knock-on effect onto what obligations they attract, or what specific exemptions apply to them. In addition to exemptions applying for specific types of contract and authority, there is also Northern Ireland specific exemptions. If any of you are involved in advising on cross-border procurement, be particularly careful around that, because not all exemptions that apply to Northern Ireland authorities apply to cross-border procurement. Again, I'll come on to that a little bit later. So moving on then, the first phase after the plan phase is the define phase. So this stage of the process is of particular importance for contracting authorities, and you need to be careful of your terminology within the Act, because there is a lot of things that you must do, and there's a lot of things that you may do. Now, equally on supplier side, you want to be aware of that, because you want to understand what firstly, has the contracting authority complied with their obligations? If they haven't complied with their obligations and satisfied the criteria under the Act, what impact does that have on the contract? And subsequently, what impact does that have on you and your business? So Section 16 sets out the pre-market engagement element of the new Act, and it sets out that contracting authorities may run pre-market engagement. When they've decided to run the pre-market engagement, there's a lot of obligations that then fall into the must category that they must comply with. Now, that's really important, because if you're a supplier and you're interested in a particular contract, that's your opportunity to mold and influence and explain to the contract authority, well, look, we know you're suggesting X, but here's why Y works better for the sector. It's your opportunity to have your voice heard. If you're the contracting authority side or advising the contracting authority side, that's also really important, because There's no obligation to engage in the pre-market engagement element, but once you have set upon that, you're then taking on additional obligations under the must criteria. So that's really important to be thought about right at the early stages of any procurement. One welcome development, and it seems to be welcomed across the board by contracting authorities and suppliers, is that the choice of procedure has been simplified. So previously you had 5 different procedures ranging from open, restricted, negotiation, whereas now that's all been cut down to 2 procedures, one being the open procedure, which is very similar to what went before, and anybody involved in either bidding for contracts or as a contracting authority or public utility will be well aware with the open procedure. It's probably the most commonly used, but for specialist products and services or goods. Now we've moved into a new flexible procedure where the contracting authority can design their own procurement procedure so long as they're treating everyone with the Section 12 objectives in line with them. And I'll call out the Section 12 objectives to you later, but essentially it's obtaining value for money, integrity throughout the process, very similar to your old public procurement principles. Your Section 18 principles under the public contract regs, which are equal treatment, transparency, non-discrimination. All of that is very similar in the new world, but with slight nuances. And as I touched on earlier, we think that'll have an impact on how case law is interpreted and how closely the Northern Ireland and UK judges might stick to previous precedent. Again, so moving on to an additional obligation on the contracting authority, there is record keeping obligations and good administration obligations for contracting authorities presently. However, Section 98 of the Act sets out specifically that records must be kept for 3 years. And that doesn't just count for the decision to award the contract, that's for every process carried out, all the decisions that led to a certain contract award. Now, again, that, and I'll come on to this a bit later as well, that is really that could potentially be used to the benefit if you're a supplier and you think, do you know what, I'm not happy with how that their procurement process was run, but I was out of time to take a challenge at the outset. As the procurement process continues or as the contract continues, you will now have new grounds of challenge. So just taking a practical example, you don't win a contract as a supplier because you thought, you know what, that criteria, it's too difficult to meet. Another bidder goes forward, meets that criteria, but you know from your market knowledge, they're going to struggle to satisfy that criteria. Because of new transparency obligations, further down the line, you'll understand whether that criteria is being met or not. In a lot of the instances, through poor performance notices, KPI notices, you will now have more market knowledge. So if you then want to go away and bring a challenge subject to a ground arising, you can always go to the contracting authority and say, okay, authority, we know you awarded that contract. We told you at the time that the other party couldn't meet it, but you've awarded it anyway. Show us your records. And then that might give you, one, it gives the authority more transparency obligations, but 2, it might give you a route to challenge if that scenario was to arise. So you'll see all of these new obligations on the contracting authority cuts across to the supplier side as well, and vice versa. Where there's new obligations on the suppliers, it often will work to the benefit of the authority. Conflict management is also specifically called out in the new Act, which is the grounding principle for managing conflicts is integrity, which is set out in Part 5 of the Act. For example, a contracting authority must take all reasonable steps to identify and keep under review, and that's really important, keep under review conflicts or potential conflicts. Now, again, that's a bit of a step change away from what previously went before, where conflicts would have been assessed at the outset of the procurement. If there were no conflicts, subject to something really important arising, the conflicts probably weren't really considered again. Two important steps here is that one, there is an obligation to keep conflicts under review, and two, that if they arise, it's not necessarily due to something you've done. It could be something to do with what your subcontractor has done, or a new relationship they've struck up, or, for example, using an accountancy example, huge accountancy firm, you might have applied for a contract. You had no knowledge of a prior contract or prior information. That contract is won, it's then handed off to the team that's going to manage that contract, and a contract arises. That will potentially cause difficulties, especially if you're working with, one of the government departments, or one of the bigger firms, because obviously, they'll be quite active in the market. So there is a potential throughout the contract the conflict could arise, and then there's duties to mitigate and resolve that conflict. So moving on then to the procure stage. Um, it's important that bidders and contract authorities alike appreciate that whilst the process may not look dramatically different, it is looking at the detail that is going to be important, because the terminology has changed, but the underlying obligations are very similar, and it's going to be stress testing. How does that impact you? How does this new terminology impact you as an authority or as a supplier? How does it impact the authority's obligations to treat you in a certain manner, or treat the procurement in a certain manner? Um, for example, there is conditions of participation, which are essentially the new selection questionnaires. Um, but there's a specific obligation on the authority to act proportionately. So if you're going for a contract, the authority decides to publish conditions for participation to cut you out of the contract. Is that proportionate? How does that work? What are their obligations? This is all probably going to be the subject of case law going forward, because where there's any ambiguity, and there's plenty of it in this new Procurement Act, there's opportunity, and people will, I, in a lot of cases, genuinely feel aggrieved at being not being awarded these contracts for one reason or the other. Another concept that a lot of you'll be familiar with is the award of a contract to the most economically advantageous tenderer. That's now changed from MEET to MAT, the most advantageous tender, so from MEET to MAT. And that's really important because it's removed the economic element. So the contracting authority no longer has to show that it was the most economically advantageous tender for that authority, but the most advantageous tender, in theory, could have wider benefits to the public or to society. So if you're a supplier and you're looking, okay, well, I'm going to go for that contract in 12 months' time, what does that authority care about? Do they care about their green credentials? What is going to be the most important thing they're going to put in the contract? If they're moving away from price, what are they going to replace that with? Now, there's the underlying obligation to secure value for money, but that doesn't preclude the authority from including, I don't know, environmental credentials, for example, within their procurement. So as a supplier, especially for if you're a smaller supplier, or if you're advising a smaller supplier for again, accountancy services, it may be, are your green credentials up to date if you want to go for that contract? Is that something you need to be thinking about? If the same authority has published a new procurement last week, what is the stuff in there that they are now putting in under this new regime? So it is important to be alert to this, that these changes. Again, another one of the changes brought in is the abnormally low tender, and how this going to impact the assessment of the operation of the contract. So quite often we would get queries, and I would say Well, we're market leaders here. We understand that we put in a good competitive bid. We understand that that contract cannot be carried out at the price that the person has just won the contract says it can. That's okay. Starting point, a difficult challenge to win because unless very specific criteria has been met, i.e., the successful contractor might enter into an insolvency arrangement, or there's some sort of underlying reason that the authority had to go away and review the abnormally low tender. Generally, they're very hard challenges to win. Um, where now the difference may well be that you come along, you say, no, that bid could not possibly be sustainable. There's no way for the successful tender or supplier, as the terminology now is, to carry out the contract. 12 months goes by, you raise this with contract authority. They say, no, it's fine. We checked it. There's no insolvency arrangement. 12 months goes by. The authority is now in difficulties. The contract's not being performed well. You now know about that. You now have the opportunity to go back and say to the authority, hang on, you awarded this contract. What is going on? Why could you possibly have awarded the abnormally low tender when we told you it was abnormally low? Whereas before, that maybe wasn't quite as easy to do because any issues or any difficulties arising under the contract were dealt with under private law, whereas that's not going to be the case. All of this stuff is all interlinked, and it's all going to be the subject to transparency obligations that arise under the Act. Couple of other points just before I move on. The ability for a contract authority to exclude a supplier during the course of a contract is also being bolstered, and that is in line with the transparency obligations where they have to publish notices, which I'll come on to. But if you are an excludable or excluded supplier, and or you are an associated or connected person. And this is where it all comes down to the terminology and being careful who you're entering into subcontracts with, who you're entering into partnerships with. Become an excludable or excludable supplier. You could also be terminated for your public contract. So it's not as simple as, oh, I've kept myself right. I've met all the criteria. You need to be really careful at the outset what the position of any business partner or commercial partner is in before entering into that contract. Can they demonstrate, like, we can report to the authority, we're not in any difficulties amongst other contracts that have nothing to do with this contract. We're not really at risk of becoming an excluded or excludable supplier, because if they do, that could have a serious impact upon your business. If you're supplier side. And also, of course, the contract authority will have to grapple with, okay, we have a good relationship, this contract is being performed well, but actually someone you have a relationship with in a business capacity has been made an excluded supplier. How do we do that? How or do we terminate you? Do we novate the contract? Or do a lot of the issues that are going to arise there? Finally, one point on standstill periods is they've now changed from 10 days to 8 working days. So all the hard work's been done. You get the standstill period. And just touching on that in real life relationships where the supplier has a good relationship with a contract and authority, the first thing you do generally is you reach out to the contract authority. You've got your standstill letter. You're disappointed. You say, I am disappointed. I really thought I'd get this contract. Here's the reasons why. Can you give me some more information? The contract authority, 2 or 3 days go past. The contract authority then sends you a letter, gives you a bit more information. You're now 7 days, 6 days into the standstill period. You need to protect your position. So you need to move quickly if you are minded to bring a legal challenge. Because after the standstill expires, and don't be caught out by holiday periods or working day or weekends, because it's now 8 working days, so it's slightly more difficult to calculate. But it's the same as under the previous regime, where once the contract is gone, say for very specific circumstance where you can get a declaration of ineffectiveness, you're into a damages claim. Most suppliers, in our experience, don't want to be bringing litigation against a contracting authority. They want the contract, they want the commercial value under the contract, they want to perform the contract or continue to perform the contract, as they probably have been doing for many years in some instances. So if you have an issue, it's really important that you act quickly, and bear in mind, just raising the issue isn't going to be enough to stop the contract from being awarded. Um, I raise this because, not because it's changed, that position has remained very much the same, but what has changed is how the standstill period is calculated, and your ability to engage over 10 days, which generally it may well be 10 days after bank holidays or whatever, but all be subject to that'll all be subject to the specific time and the standstill letter is awarded. So if there's one thing you can take away today, is act promptly. And equally, if you're a contracting authority, you want to act promptly given that supplier their response, because you want to say to them, look, understand your concerns. Here's why our position is, here's why we got here to award the contract to your competitor. There's the information, and cut off challenges at the earliest possible opportunity. So early engagement really is key, and you'll see that's a theme in the Procurement Act generally. But for anything around standstills, bringing a challenge, raising issues, it really is key to move very, very quickly. Yeah, so all right, touching this, so not spend much time, but just really important, get your head around the terminology, understand what your requirements are. Using a very, very basic example, if you're a supplier, you have to register on the central digital platform. A lot of time, as you'll know, and it's not ideal, but there's tight deadlines. You need to get your bid in. The last thing you want to do is be going on, go to submit your bid, have you registered for the central digital platform. Fairly basic admin stuff. You need to just have a good understanding of what your requirements are. Leave yourself plenty of time. Don't rush. Don't rush these bids. Not that that was ever a good idea, but more so now, that is really important to make sure that you understand what the requirements are, where the contract is being advertised, all that type of thing is now going to take up a bit more importance. So moving on, and then the talk this afternoon is very much broken down into two parts. The first part was the general changes which we've now done. So the thing that we seem to be getting the most queries about is this stage, the post-contract award stage, and I've already signposted that this was going to be the big issue, but I'll hopefully not spend more than 15-20 minutes on it. So when you move to, there's new the performance stage of the contract. So procurement has been done, contracting authority done a great job, defined stage, got the contract awarded, right through procure stage, standstill has been issued, we're now into the performance of the contract. So a couple of the new transparency notices are to be published at performance stage, are that coming up in the next slide, but a couple of the key changes I thought I'd just pull out for you is new transparency notices. Termination rights for contract authorities have now been bolstered, albeit there was always some implied termination rights. And importantly, the statutory duties under the Act continue to apply during the life cycle of the contract. So we're no longer in a world where contracts awarded, disputes arising under the contract are dealt with as a matter of private law, albeit you still have your private law rights. So just going into that a little bit further, the public contracts regulations, the utilities contracts regulations, concessions contracts defence regulations have very little to say about the performance stage of the contract. A couple of examples, Reg 72 and Reg 73 deals with unlawful modification. Reg 113, which will be of interest to accountants, is that there's prompt payment obligations. Other than that, there's very little within the regulations to regulate a performance of a public contract. And in fact, in the case of IGT versus the Gambling Commission 2023, it was actually shown as quite difficult to bring a challenge against the performance of a contract if you're the successful contractor, because you have the contract essentially to fall back on. So in summary, you're into a private law dispute rather than holding a contracting authority to their statutory obligations under the previous regime. That has now changed, and as well as your ability to bring a challenge under the procurement regulations, or sorry, the Procurement Act and the related regulations, you also have potential grounds for judicial review arising, because the Act now brings the performance stage out of the private law, albeit you still have your private law remedies, into the public law realm. And this is demonstrated clearly at Section 1 of the Act that defines procurement as the means the award, entry into, and management of the contract. And then it goes further at Section 2. It says any step taken for the purpose of awarding, entering into, or managing the contract. So it's quite clear the scope of the legislation now extends way beyond the procurement phase. The broad definition of any step for the purpose of awarding or entering into or managing a contract um, is a vast departure from where the previous regulations were. So just in summary, the Act, the related regulations cover the entire procurement life cycle of the contract, from preliminary market engagement, transparency obligations, and enforcement. So some of the new transparency notices, and there are a lot of them, which are a further obligation on contracting authorities, um, but also an opportunity for suppliers to monitor contracts, competitor contracts, check and see what's coming up, check for any modifications, amendments, um, are quite cumbersome actually on the authority. So the more you're over the detail of that, the more you're over the detail of what contracts have been awarded, what contracts are being performed, what contracts are due to expire, the better position as a supplier you're going to be in. But from a contracting authority side, it is going to be, unless you've got some sort of IT system monitoring when you need to publish what notice and what information you need to put in it. And the central digital platform, in theory, was supposed to do this, but I understand it's not functioning the way we had hoped. You do need to know when do these obligations arise, what do we need to publish and when. So just some of the notices are contracts details notice, contracts performance notice, contracts termination notice. Touching on the contracts detail notice first, that notice informs suppliers and the public that the contracting authority has entered into a contract. Although what it also does is it puts an obligation for contracts with a value in excess of £5 million on the contracting authority to establish 3 key performance indicators. Fine, no one's really going to be surprised. The KPIs or service level agreements are in their contracts. What it is now is that they're now mandatory. They now need to be assessed at least once a year, and they're also going to be published. So again, you can see immediately that there's potential issues here. Not least that your competitor will know, if you're a supplier, are you performing your contract correctly? The contract authority side, they will also know they have to be proportionate when publishing. So in summary, there's 3 changes that are going to be brought in, as well as the broad definition of a KPI, that they're now going to be monitored, published reported on all throughout the life cycle of the contract, which is a stark departure from where we previously were. So ultimately, the KPIs will be assessed, they'll be published, any information needs to be reported on by the supplier will be done so, and then the notice will go out. There's some scenarios where the contract can't be assessed by reference to KPIs. So for example, so a very curt example somebody provided to me before is if I'm buying £6 million worth of stables, I just want my stables. I don't need a KPI, which I thought was a fair enough comment. But where the risk lies is one, if your reputation is tied up on your good performance of your contracts, all other contracting authorities will have sight of your assessments. Now, whether they use them against you or not, they shouldn't. Every contract should be assessed individually, or every bid, I should say, is one thing. But also, and probably more concerningly, is that your competitors will also know, your customers will know, everybody involved or the public at large will understand how you're performing a particular contract. That's obviously not ideal for a lot of contracting or suppliers contracted with public bodies. And that applies across services, legal, accountancy, whatever goods contracts, whatever it may be, if it's a contract in excess of £5 million, there's an obligation on the authority to assess and report. Where there's risk for the contracting authority is if you get this wrong, and if you publish that assessment and the supplier takes issue with it, the supplier does have recourse under Section 100 of the Act to bring legal proceedings against you. So you do need to be really careful to get it right, to treat suppliers in a proportionate manner. And also make sure your KPIs are balanced in a way that you're getting the benefit of the contract. And the KPIs are being utilized as a tool to help you do that, but also that they're not so cumbersome that suppliers in constant default, and also not so easy to meet that they're of no value. So there is a real balancing exercise to be done there, and it affects both contract authorities and suppliers, because if you're a supplier and you're good at what you do and you're good at managing contracts and you want those KPIs to be there because you know what you'll need to bid, what price you need to put in to run the contract well. So if it's a scenario where the KPIs are just low, there's a real potential for someone to put a real low bid in, knowing that the KPIs are easy to hit, but knowing that they're not going to perform the contract to the same standard as what you might have. Just before moving on from KPIs, there are scenarios other than where they can't be appropriately assessed, where they're not going to apply as a mandatory obligation. That's frameworks, utilities contracts awarded by a private utility. So again, this goes back to understanding what your status is under the Act and understanding who you're contracting with, if you're supplier side. A concession contract or light touch contract. Our query has been, and we're not seeing, it's probably a bit too early to tell, is will this lead to a trend of more framework agreements being used, because it'll remove quite a cumbersome obligation onto contracting authorities. And a couple of years ago, frameworks were a bit more trendy and people seen the attraction to them. But the last 3 or 4 years, they've kind of fallen out of favor for one reason or the other. And that's probably because they come with their own management headaches. So, and then kind of covered this in under KPIs, but I just thought again it's worth touching on just to show the extent that the transparency obligations will impact you if you're not performing a contract to a high enough standard. So within 30 days, if there is a breach by a supplier that leads to remedies, including partial termination or settlement, the contracting authority has to publish the supplier default. The contract performance notice must record the performance of the supplier against the KPIs, but there's also this additional obligation for public contracts, not just those above 5 million, which applies to all contracts, including frameworks and concession contracts. So I know I've touched on this, but it really is about early engagement, understanding what obligations you're signing up to. Can you meet them? Are you overextending yourself? If you lost one member of staff, is that going to have a detrimental impact? What impact is that going to have on the business as a whole? The same with the who you're contracting with is who are your connected people, who are your subcontractors, who has influence over the company. It just a lot more thought has to go into entering into public contracts. Um, and that's not to say that a lot of thought already doesn't go in, because they're hugely labor intensive, and submitting bids takes up a huge amount of man hours. But that's not to say that there's not room for improvement, and there does need to be a lot of thought going into entering into these contracts before these default or supplier performance issues arise, just to protect you and protect the business, or protect your client that you're working with. Implied termination rights, I'll not spend too much time on this because there has always been implied termination rights. In instances where legal proceedings have been taken, but Section 78 of the Act provides contracting authorities with implied termination rights for public contracts, where the grounds for termination, the contracting authority considers that the contract was awarded or modified in material breach of the Act or regulations made under it. Again, there's going to be a dispute about what stacks up to a material breach. So if you're drafting the contract and you're drafting a clause around material breach, it's really important for contracting authorities to set out clearly and precisely what constitutes as a material breach. If you are supplier side, familiarize yourself with the contractual terms. Find out what is a material breach, what does it look like, really examine, delve into the detail in this specific sector or industry. What is likely to occur that might be considered a material breach? What's outside of my control? That's really important. That's really important to give some thought to at the outset. Again, if a supplier has been awarded the contract, becomes an excluded or excludable supplier, that is also termination grounds. A supplier other than an associated person, or the supplier's subcontractor, to which their performance forms an overall part of the public contract, becomes an excluded or excludable supplier. So again, make sure before any contracts are entered into, you know who you're in business with, you know who you're in partnership with, and you're really stress testing whether they can deliver the contract. Because if a connected person becomes an excluded supplier for one of their contracts, even if it's unrelated, it may well have a detrimental impact upon your contract with a particular contracting authority. And again, from a contracting authority side, they have to monitor that. They have to keep on top of that. It's a huge administrative burden, as well as updating all of their procurement documents and all of the terminology and all of the new processes and transparency obligations. They also now have to monitor, essentially, to some extent, um, or monitor is probably not the right word, but they have to consider whether they should terminate the contract using these implied termination rights, because of course they have to act with integrity, they have to be proportionate, but that's not just to the contractor, that's to the economic operators as a whole or other suppliers. And just touching upon what I said throughout the talk is any decision now under the procurement phase, the performance phase, whatever it may be, is now subject to challenge under Section 100 of the Act. And that's everything from your Section 12 principles of maximizing value for money, maximizing public benefit, sharing information so suppliers can understand the policies and decisions, acting and being seen to be acting with integrity. Again, that's really important for a supplier because if something arises during the course of the contract that you think, that wasn't right, I would have bid for that contract, but for that information wasn't published or whatever it may be, you may well have grounds of challenge and tied back into the tying that back into the record keeping and that type of thing. There is a commercial advantage to being vigilant with a lot of these things. And that's not to say that suppliers or accountancy firms or whoever it may well be wants to run off and challenge these authorities, but it at least gives you a mechanism whereby to ask questions to say, hang on, well, why is that? We didn't bid for that contract because we couldn't meet the KPIs. And now the KPIs aren't being met. Why wasn't that checked? So it gives, and the authority probably thank suppliers for that approach and then that engagement because it helps them improve their processes, helps them improve their engagement with the market, and ultimately it helps them obtain better value for money. But probably more likely is you're a supplier, you're performing under the contract, the authorities made some sort of decision, maybe it be publish a KPI assessment that you don't agree with, that is probably more likely to be your grounds of challenge because it has a tangible and real world impact. So there is a real benefit for the authority, and if you're advising authorities, to take the time, consider, make sure you're taking a proportionate and careful approach before taking any steps really under a public contract, especially high value public contracts, which a lot of them in Northern Ireland and UK are. So that you'll be glad now brings me on to the final proportion of the talk, which essentially is 10 key takeaways. I thought it was worth just reiterating, and much of them I've already touched on. So know your terminology, especially if you're authority side, all of your documents are going to have to be updated to reflect the correct terminology and the correct legislative provisions. But also if you're a supplier or advising a supplier, make sure you know exactly what the implications of taking certain actions are going to be. The award procedures are a lot more streamlined. We now have the open procedure and competitive flexible. Competitive flexible is probably welcomed by everybody involved in public procurement because one, it gives the contract authority the flexibility to design and run a procurement process in the way that they want, the way that best suits their objectives. But also it gives the supplier an opportunity up until the bid submitted to say, hang on, authority, what have you thought of this? Can you amend that or whatever it may be? Here's a clarification. Can you clarify what you mean by this? Now, there's clarifications have always been allowed in public procurement, but what has changed is there's new flexibility now for the authority to go away, have a think about it, and so long as they're acting in line with the Act and their Section 12 principles with integrity, they do now have a bit more flexibility to change that. So hopefully, as time goes on, that works to the benefit for the authority and for the public purse as a whole. Open frameworks, well, I've just jumped off it, so I'll just move on from it. But open frameworks are really, really interesting. It goes back to that point where I was saying suppliers should be monitoring these notices, because the idea and the concept of an open framework now is that as a supplier, you won't be iced out of any particular service or contract for too long. The authority will open them up, whatever it may be, once a year, allow new people onto the framework, um, and ultimately it creates more opportunity for you. But if you're the supplier, you need to be alert to it. Otherwise, you'll not be able to avail of the opportunities. If you're contracting authority aside, it's great because you're inviting more competitive tension. You're inviting more people onto the framework. For one reason or the other, couldn't join it as it when it nicely opened, and you're creating more competitive tension for the mini competitions. That can only be a good thing so long as it's run well. And also, it probably lessens the risk of legal challenge, because suppliers might think, okay, well, I didn't get onto the framework at this stage, but it'll be open again in a year. It's not a 150, 200 million pound contract. If I don't do this, I'll not be in the market for 10 years. It'll open up again and you get another chance to go. So hopefully that'll lead to a reduction in litigation, which is ultimately, I think, what everybody wants. Everybody wants a better, more streamlined procurement process, and a cost-effective one that isn't costing everybody heartache and resource implications of defending challenges or bringing challenges or whatever it may be. Dynamic markets very similar to the open framework, but for there is conditions of participation. So again, hopefully has the same impact as the open framework. Um, the data knowledge. This is probably one of the most important aspects of you now having a right of recourse under Section 100. So if anything arises that you think, you know what, I'm not pleased with that, or I need to bring a legal challenge, you have the 30 days from the date you knew or ought to have known to bring the challenge. So that's the same. A lot of anyone who's involved in public procurement will be very familiar with that legal test, i.e. the data knowledge and the date you knew or ought to have known. But what's different now is usually that starts when you get the standstill letter. It expires after that, and that's the end of it. No longer the case under the new act because there's new grounds of challenge. Litigation, the best way in our view to avoid litigation is early engagement. Um, that's contract and authority side, that's supplier side, early engagement. If you have an issue, put your hand up, engage with the authority. Again, no, but the courts are filled with these procurement disputes, and I suspect quite a good proportion could have been avoided had there just been a more sensible approach taken at the outset, or a bit more engagement. Um, and I have a lot of sympathy for contract authorities, because once you have published the tender criteria, you have to stick to it. Whereas we're now moving slightly away from that, where the authority in certain circumstances can amend the procurement documents up until bid stage under certain procedures. So look, litigation, best avoided if possible. Let's engage early on both sides and try and avoid it where you can. Standstill period, I've already touched on that. If an issue arises, it is super important that you seek legal advice at the earliest opportunity, because once the standstill is expired, you are into a damages claim. Nobody really wants that. In our experience, what you want is the contract that you feel that you are entitled to or entitled to bid for. Meet the mat. Interesting to see how this one pans out. Taking away the economically wording may have a wider impact for environmental, that type of thing, social value. But there is the underlying obligation for the authority to secure value for money. So it'll be interesting to see how it actually plays out. But worth noting that the authority no longer has to use the assessment of meat. Cross-border procurement leaves a lot to be desired. There is mechanisms for Scotland, the rest of the UK. There's no such mechanisms for Ireland or UK, EU. So like yourselves, a lot of our colleagues in Dublin, you may want to you may want to work with those guys, or you may be advising organizations that have a cross-border element. But in reality, it's very difficult to carry out a cross-border procurement for a contracting authority. It comes with some risk, at least, and from supplier side, um, it might have a impact because it may well delay some of these procurements going out to market. The debarment list, we've touched upon this earlier. Stay away from it the best you can. If there's an issue raised on the contract, raise it with the authority. Do whatever you need to do to engage it early and try and resolve issues and disputes. Remains to be seen. We as a firm are not that confident that it'll be used quite often because it's so draconian, and you do have the option to bring a challenge, and the authorities, contract authorities, know that suppliers have the option to challenge them, but remains to be seen, and hopefully it doesn't become a thing, where people are end up on it too lightly, because it has a serious impact on any business, really, because it potentially prevents you from being awarded public contracts. Contract management, just same as today. If your authority really need to start thinking about how you alert yourself to when certain notices are required. If you're a supplier, think about it before you enter in. Make sure you're interrogating any contractual clauses. Make sure you're giving the authority the information that you've signed up to give them, so that they can report on KPIs, or whatever it may be, or at least understand how the contract is being performed. So thank you very much for your time. I'm happy to take any questions that you might have.
Stephen, certainly a lot to take in there. So look, we have a couple of questions and I'm conscious of time. So just very quickly, are you aware of an article within the Procurement Act that states that if there is another agreement in place, such as a finance agreement between EU member states, then NI public bodies may be permitted to set aside UK Procurement Act 23 procurement regulations and instead apply EU procurement regulations when procuring goods or services within Europe, e.g. Peace Plus funding?
Yeah, so there is a number of specific directives that bind NI authority or NI operators with Europe, but it's not as clear as that, Gillian. It's a really complex area where we have raised this with the Cabinet Office, specifically to say, hang on, there is obligations, underlying obligations, for example, Peace Plus, on these organizations, and you're telling me that to go through procurement they fall into the old rules. There's no specific provision, as far as I'm aware, in the rules for that. And we have raised it with the Cabinet Office, and they have essentially told us that we need to each operator needs to assess for themselves. But there's nothing. It's just there's just no neat answer to it, unfortunately.
Okay. And lastly, will supplier details migrate from eTenders NI, or do they register with the new database?
In theory, eTenders should send all the data to the central digital platform. I understand from our authority clients that it isn't really working that well. And so make sure, the important thing is, if you're a supplier, make sure that you're registered for the central digital platform.
Okay. And one more just said, is there any de minimis by value for application of the Act?
Yes, so very similar to the old thresholds, which for services is, I think, around 300,000, but depends on if it's goods, works, or services. And the below threshold specifically is called out in the Act, which again is a much more extensive than what was previously went in the old regs, but it doesn't, as we understand it, apply in Northern Ireland.
Okay. Right. There's nothing else in. We're at 2 minutes past 2. So thank you once again, Stephen. And thank you for joining everybody on the call, and enjoy the rest of your day.
Thank
Thank
you.
you.